As the Supreme Court ruled on the consequential ballot case in Wisconsin, the Senate confirmed Amy Coney Barrett to become the nation's newest justice. Justice Clarence Thomas swore her in last night at the White House, sealing a 6-3 conservative majority on the high court. It comes just days before the election and after more than 64 million voters casting their ballots. For some legal analysts, for some legal analysis, rather, let us bring in Kim Wehle. She's a professor of law at the University of Baltimore. All right, Kim. So the ruling in Wisconsin to block an extension on counting ballots comes a week after the court allowed Pennsylvania's ballot extension. Explain to us what the differences are with Wisconsin and Pennsylvania and what it means for the election.
Well, the court is basically drawing the line at who is making the decision to extend the time for counting ballots. In Wisconsin, essentially, it was a federal judge. And so the majority said, listen, federal courts are not in the position to upend state legislators' decision-making. So that's really the distinction. If it comes from a state legislator, the legislature passes a law that changes the election deadlines, then this conservative majority will uphold it. If it's a judge that does it under the Constitution, then that's where the court is drawing the line, essentially saying two things. One, it's up to legislatures, not courts. And two, frankly, in this decision with respect to Wisconsin, in Justice Kavanaugh's concurrence, he said, and as did Justice Gorsuch, listen, it's not so hard. Voters have lots of opportunities. You know, if you want your vote to count, you better get going and get going and get voting. Basically, it's not up to us to make it easier for you in a pandemic.
So in an unusual move for a new justice, Barrett made a speech after she was sworn in. I want to play a little bit of what she had to say.
A judge declares independence not only from Congress and the president, but also from the private beliefs that might otherwise move her. The judicial oath captures the essence of the judicial duty. The rule of law must always control.
So despite what she said in her speech, there are obviously some concerns about the way she may rule on certain cases, certainly concerns among Democrats. So there's a likelihood that the High Court will take up more voting-related cases after the election. And, of course, there's also the Affordable Care Act and other cases. How will her confirmation impact some of these cases, the election, the Affordable Care Act?
Well, I think there's a real myth floating around that somehow originalism or textualism means that judges act with extraordinary restraint as opposed to maybe a progressive judge. So really the question, I mean, we just talked about how the court essentially said when it comes to voting, too bad voters, you have to go to the legislatures to get that fixed. And that raises the question of whether legislatures are really reflective of the democratic process because there's so much gerrymandering. So the question, I think, for November 10th, where the court's going to hear the challenge to the ACA with a Justice Barrett on the court, is will this conservative court likewise respect the will of the people through the federal legislature, that is the Congress? Will they apply the same kind of restraint that they're claiming to apply to defer to state legislatures in voting? Will they use that same methodology to defer to the United States Congress when it comes to 20 million people whose medical care is actually on the line? I'm not so sure. I think this particular justice, she claims to read between the lines, but originalists have been quite aggressive when it comes in particular to election and voting rights. We saw Chief Justice Roberts preside over a case that struck down a critical provision of the Voting Rights Act in 2013, which has now allowed more voter suppression efforts to creep back into the electoral process. We also saw the court strike down a critical provision of the McCain-Feingold statute that essentially kept lots of corporate money and dark money out of politics. Now it's flowing back into politics, and some argue, as Sheldon Whitehouse did, the senator from Rhode Island, during Justice Barrett's confirmation hearing, that it's that money that's essentially packing the courts. It's floating into the judiciary and cementing a minority rule in the federal courts. And that is consistently, I would say, ruling in favor of corporate interests. Sheldon Whitehouse also cited statistics in the 85-4 decisions that have come down recently. All 80 of them favored corporate interests over sort of minority interests. We can debate whether that's the right way or the wrong way to come out on the law, but that is the impact and the trajectory of a conservative federal judiciary.
Kim, let me ask you a quick question, and this might be, I don't know if this is sort of a juvenile question, but you mentioned originalists, right? The way she interprets the Constitution. It seems often, and with what you just said, it sort of aligns with that originalists often align with conservative politicians, right? A conservative political sort of way of seeing the world aligns often with originalists. But why is that the case? If it's just a matter of how you view the Constitution, how this document should be interpreted, why does it seem like conservatives and originalists are often in lockstep?
Well, I mean, you see over the history of the United States Supreme Court, it's sort of ebb and flow in terms of whether, like we saw under the Warren Court, the Burger courts in the 1960s, the court decides, listen, we need to use the Constitution to expand individual rights. And some would argue that a conservative court, sort of fueled by the Federalist Society, conservative type think tank, is trying to roll back those protections and basically limit government and enhance the role of the free markets, that is, large corporations. Originalism, frankly, Anne-Marie, is really a smokescreen for a political point of view, because even in Justice Barrett's confirmation hearing, she said, listen, I just apply the plain language, but when I do that, I look for the original public meaning. Now, I can't get in my time machine and go back to 1787 any more than she can to decide what the original public meaning was in 1787. There weren't recording mechanisms. I mean, that is, by pretending to sort of strictly read things based on original public meaning, of course, she and other conservatives can inject their own political viewpoint under the guise of being neutral. I mean, it's fine. All judges judge. All judges interpret ambiguous language. My issue with originalism is the pretense that somehow they're not doing that. And I would rather have us all just put on the table the real justifications for reading ambiguous language one way or the other. And some would argue conservatives care a lot about conservative principles that in this moment are not supported by a majority of the American public. I mean, 17 million more Americans are represented by the Democrats in the Senate who literally had no voice whatsoever, no leverage at all in putting the last 3 justices on the United States Supreme Court. And that's why we're hearing so many calls for reforming the court, because it has too much power and it's not functioning in a way that's at all consistent with fair representation in a democracy by we the people.
Yeah, it's such an interesting point that you're making there, Kim. And speaking of, the founding of this country and our very first president, George Washington. George Washington was not declared president of the United States the day of the election or the day after the election. It took several weeks before he was declared the winner of the election, because olden days, there was no, horses and ballots, and, there were special circumstances that warranted waiting before you were able to declare the winner of the presidency. And the other point that you were making, Kim, you talked about this idea of originalists, and now you're hearing a lot of calls from Democrats that they need to reform the Supreme Court or expand the number of seats. So in a dissenting opinion back in 2015, here's what the late Justice Antonin Scalia said, quote, "System of government that makes the people subordinate to a committee of 9 unelected lawyers does not deserve to be called a democracy." Is the Supreme Court currently set up to do its job with confidence from the American people, or are changes needed? And I will note that when you hear that term, and Anne-Marie and I were talking about this yesterday, that term court packing sort of lobbed around, let's talk about what the packing of the courts has looked like under Mitch McConnell, under a Republican-controlled Senate, under the number of Supreme Court justices that have been appointed by Republican presidents. It's easy to throw out the term packing the court because we're in an election cycle, but it hasn't really worked out to the Democrats' favor if you're to listen to the Republicans.
Right. So since 1969, I think 4 justices have been appointed to the Supreme Court by Democrats and the other 15 by Republicans, and a number of them from presidents, I think 4 or 5 presidents that didn't actually win the popular vote. I think the better terminology for it, frankly, is unpacking the court. And it's not even just stretching back to 1969 that's the problem. The problem really is what, under the Republican leadership, the Senate has done to the confirmation process, shortening the time period for deliberation of federal judges from 30 days to just a few days, taking out the ABA as a check on the legitimacy of their credentials, getting rid of basically the blue slip process whereby a member of the opposing party can veto an appellate court nomination that they don't like, a member of the opposing Senate party. All of this, what we talk about is comedy, this basic respect for people across the aisle has fallen by the wayside. It's my way or the highway. It's strong-arming. It's brass-knuckle tactics. And it's frankly destroyed the legitimacy of the court itself. That is, people are now seeing the court as a purely political arm of whoever's in power. And the senators from the Republican side have essentially said that. Merrick Garland didn't even get a hearing 8 months out from an election because we were in charge. So whoever's in charge controls the courts. That itself creates a problem with the rule of law and just legitimacy of the court itself. So there are a range of possible reforms. It's not just adding justices, which would have to be done by the United States Congress. There are all kinds of suggestions about, for example, creating a separate panel of justices that would hear constitutional questions, or having lower federal court judges, appellate court judges, and a rotating panel decide which kinds of cases the court hears, because they pick and choose the cases they want, and some believe they do that from a political point of view. There are lots of ways of making it more balanced and fair. And the benefit of that for all people is that then when the courts issue rulings, we respect those rulings. That's really the critical element, is preserving the integrity of the institution itself. And I think Chief Justice Roberts understands that, and it'll be interesting to see if he's able to persuade, for example, a new Justice Barrett to recuse herself from election-related cases that could decide an election in favor of the man who appointed her, or she was confirmed days before, in the midst of an election. And then she did, a photo op on the balcony yesterday in a very politicized kind of campaign tableau that really, really just delegitimizes the court itself. So I could go on, and I know for some people see this as partisan, but as someone who's studied the Constitution, the separation of powers for 16 years now, written scholarly pieces, been teaching students, this is a we the people moment to protect the integrity of the court. This is not a Republican versus a Democratic moment. So I think Joe Biden is absolutely right that appointing some kind of commission to look at the panoply of options that Congress has, not the president unilaterally, the United States Congress, is absolutely the way to go, because we have to get back to a situation where the courts don't seem like just another political strong arm.
Kim Wehle, I love your passion for the court and the Constitution. It's always really good to talk to you. Thank you.
Oh, I love talking to you too. So thank you for having me.
Thanks, Kim.